right, joining me now is Lok Sabha MP Manish Tewari. Mr. Tewari, the opposition has, of course, gone at lengths to oppose this proposed bill, which has gone to the JPC. One of the main reasons that it is being contended, especially where the government comes into question, is that it will equate the chief ministers, cabinet ministers, and even bring the prime minister in the ambit of justice. Equate if a civil servant can and has to step down post 30 days, why not a chief minister or a cabinet minister? Why should you get special privileges?
Well, first of all, thank you very much for inviting me on your show. I think the issues are far, far more fundamental than the ones you outlined. And since I was one of the people who opposed the bill very strongly in the Lok Sabha today, let me outline the reasons. The fundamental maxim of the rule of law, which is basic structure of the Constitution, is that you are innocent until proven guilty. So therefore, there is an implicit and an explicit presumption of innocence till the time a court does not convict you, and that conviction is not upheld by the hierarchy of courts all the way up to the Supreme Court. So under those circumstances, merely because an FIR has been registered, and there are all kinds of mala fide and vindictive FIRs which are registered in this country, and just because a certain investigating officer, perhaps on a command performance, decides to arrest that person, to then imply guilt and say that you have to step down, is specuous constitutional morality. And whenever we've tried to impose constitutional morality by the force of law, it has backfired. The classical case is the 10th schedule, the anti-defection law. It's been on the statute book since 1985. Has it stopped defection? No. Defection from a retail activity went to a wholesale activity and then has become a mega mart. You introduced the voting for the Council of States by a show of hands. Has it stopped allegedly people of very questionable credentials from coming into the Council of States? The answer is no. So under those circumstances, morality is something which is intrinsic to the mental makeup of the person concerned. You cannot impose spurious, law-driven morality for the simple reason it doesn't work. And number two, there is Article 21 in the Constitution, which is the due process clause, and which clearly says that you cannot be deprived of your life and liberty except in accordance with law. So therefore, an FIR, an investigation, even an arrest, even the framing of charges is not any explicit presumption of guilt. In fact, you plead not guilty only when charges are framed against you. And here you are opening the Pandora's box of misuse of state instrumentalities. Register an FIR, arrest that person, keep him behind bars for 30, 60 days, and remove him as a minister. You've seen what has happened. Many of these cases have been based upon, on a foundation of sand. People have been behind bars for 2.5, 3 years. Then closure reports are filed. There is no compensation for the loss of reputation, for the loss of, for the personal injury caused, for the trauma caused to the family. So where are we going by completely overturning fundamental jurisprudence which runs across the gamut of natural justice, across legal systems in the world? That's the issue.
But Mr. Tewari, you made your point there. The government says that this is a public morality, probity in public life. It goes against the grail of natural justice, which you just pointed out, innocent until proven guilty. The larger question also, sir, because this is something that your own political party has raised, opposition parties have raised. We live in a time of constant allegations where agencies are allegedly being weaponized. Do you see then agencies like the CBI, like the ED, even lower courts become political actors?
Well, I would like to take the courts out of that list which you have just elaborated. But insofar as the instrumentalities of the state is concerned, look at their record of conviction. Ask the agencies of the state how many cases they filed and how many convictions are ultimately upheld by the Supreme Court. The answer would be there in front of you. In the case of the Enforcement Directorate, many members of Parliament have asked questions with regard to the final conviction rate, not the conviction rate in the court of first instance, but upheld by appellate courts. And if my information serves me correct from the top of my head, that number is abysmal. I remember many years back, I had asked these same questions because I had brought a private member's bill to provide a proper legal architecture for the Central Bureau of Investigation. Those numbers were absolutely not encouraging at all. And weaponizing of the instrumentalities of the state, law enforcement, and other agencies is not something which the opposition is saying today. It is what the highest courts in the land are deprecating. So therefore, by trying to infuse a false sense of constitutional morality, what you are doing is you are making an investigating officer or an SHO the boss of even the Prime Minister of India. Here, the implications are so portentous that they are even incomprehensible at this point in time. I don't think that this bill has been thought through at all.
But, Mr. Tewari, okay, I'll give you an example. The United Kingdom has something called a ministerial code, which expects ministers to resign after breaching public trust, and many in recent history have done exactly that. Because most ministers now, even chief ministers, choose to brazen it out under the garb of a witch hunt. That's the reason why the government feels that time has come for a bill like that to be in place. If UK can have an understood, accepted ministerial code, then why not India?
For the simple reason that there is no witch hunt in the political system of the United Kingdom. They have.
But Mr. Tewari, isn't witch hunt subjective?
Well, that is exactly what I'm saying. Witch hunt is subjective. And so therefore, when weaponization of state instrumentalities, political vendetta, and I'm not talking about the central government at all. Unfortunately, this malaise has also percolated to the state governments. Under those circumstances, if you would have had a level playing field, in fact, any minister or any public servant, actually would have voluntarily stepped down, right? In fact, as I said, morality is absolutely a personal conviction. And therefore, if someone feels that as a public servant, he should not be holding an office, that you should leave it to his prerogative. If you try and make it driven by law, in fact, what you're doing is incentivizing the witch hunt, which you earlier referred to.
But Mr. Tewari, nowhere does the law state that the government itself, if the chief minister has to step down after 30 days, nowhere does the bill suggest that the government itself needs to be dissolved or step down. The chief minister can appoint somebody else, and after he's acquitted, he can come and take office again.
Well, in fact, that is the other anomaly with the law. It does not say after you're acquitted. It says once you are released, you can come back and take oath. So therefore, the presumption of guilt, which you are ascribing to that person, that, if you are arrested, it is as if you are quasi-convicted. And, that quasi-conviction is that, if your arrest period is beyond 31 days, you have to step down. And the moment you get bail, you can come back and be sworn in as a minister. So therefore, ultimately, this is neither here nor there. I could have understood that if you would have said that, let's say post acquittal, a person can come back. But in India, the reality is the process is the punishment. If a criminal case starts against you, it is not only you, but your coming generations for 3 generations will keep fighting it. So in India, unfortunately, conviction is not the punishment. The process is the punishment.
The
So
question I'd like to ask you.
Look at the figures in Indian jails. Almost 88% people are under trials who do not have the money, to furnish bail so that they
But
can
then,
come out
Mr.
of jail.
Tiwari, the same yardstick is applied to civil servants in this country. What makes our chief ministers and even the prime minister so special?
So therefore, in fact, according to me, that presumption of guilt, which is applied to the civil servants, is also wrong, because it is not only politicians who are subjected to witch hunts. People who are sitting in an administrative authority, who are taking decisions day in and day out, if you do not provide them with some kind of protection and insulation, and that is why the Prevention of Corruption Act was amended and 17A was introduced as a safeguard, nobody will be able to take a decision. Because let us suppose you take a financial decision of some import, and you obviously have somebody who is going to be benefited and somebody who's going to be harmed.
Not just long drawn out court cases. There are problematic laws like the PMLA, which where somebody can be denied bail for full 30 days, and then automatically the person would need to step down. But I'll ask you a larger question, Mr. Tiwari, and that question comes in from, it's gone to the JPC, but wouldn't, you're a lawyer, in your belief, wouldn't it require 2/3 majority from the House for this bill to pass, as it's a constitutional amendment?
Well, that's the oxymoron. So the constitutional amendment will require 2/3, but the Union Territories Amendment Bill and the Jammu and Kashmir Reorganization Bill would only require simple majority. So had it been a case whereby it was restricted to a constitutional amendment, since the bar of 2/3 is fairly high, it could have merited some discussion in a joint parliamentary committee to try and see what are the pros and cons, weigh the arguments on both sides. But here is a case even where if the constitutional amendment fails to pass muster, the other two bills will pass by simple majority. And as I explained right in the beginning, you cannot turn fundamental jurisprudence, which is basic structure, rule of law, parliamentary democracy, collective responsibility of the cabinet to the legislature, removal from the legislature on conviction. All these constitutional safeguards cannot be thrown to the winds.
Okay, but I'll come back again, Mr. Tiwari. So 2/3 majority would be needed for passing this specific bill. The other two is simple majority, but a special majority would be needed in this. Correct, sir?
Yes, for the constitutional amendment, you require a 2/3 present and voting.
Is there a grey area? Because if you look at, the abrogation of Article 370, that actually happened with a simple majority, and that was a constitutional amendment.
Well, so therefore, Article 370 was not a constitutional amendment. Article 370 was actually a resolution which interpreted,
because it was temporary in nature,
Constituent Assembly to mean Legislative Assembly, and the Legislative Assembly, because it stood dissolved, Parliament stepping into its shoes, acting as the Legislative Assembly, and then abrogating 370. That also is an irregular procedure, which frankly has been held to be ultra vires by the Supreme Court, that you cannot use an interpretation clause and amend the Constitution.
Mr. Tiwari, can the grey area of a joint sitting route be taken in this? Because Article 108 is a little unclear on that front.
Well, in the sense, you can have a joint sitting of both the houses. If I recall correctly, when the Prevention of Terrorism Act was passed during the NDA-BJP government, They perhaps did not have a majority, constitutional majority or a two-third majority in perhaps the upper house, and there was a joint sitting of both the houses. So yes,
Okay.
all those possibilities are there,
Are there.
but we are not there as yet. How
Okay.
can
So-
any government actually bring in a bill which affronts and assaults the basic structure in such a direct manner? You know, it completely defies any comprehension.
Sir, I'll ask you a final question. So till now, the opposition calls all of this diversionary tactics. Do you just read it as that, or do you think there is intent behind it? That the government will find a way, be it by the virtue of an ordinance?
Diversionary or intent, the implications are very portentous. If this goes through, essentially what you have done, you've altered the fundamental basis of criminal jurisprudence in this country. And that's the worry.
Mr. Tewari, I really appreciate you taking the time out and joining us, sir. Thank you so much.
Thank you very much.
Appreciate it, sir. Thank you.
Thank you.